And, good afternoon, everybody. Dr. Deshpande just spoke about the consent, how important it is, how valid it is. Despite a very valid consent, the court can definitely find an alibi. As he said, a valid consent may protect you from criminal negligence, but the court will certainly go into the merits of the case, considering the negligence aspect of the case of the patient the patient complains against you. So there are many ways to actually find an alibi to declare inadequate consent and compensate the patient. We also need to consider the temptation of the insurance companies nowadays to suggest mediation as per the new CPA Act. So based on this background relating to a valid consent, what should be our thing from our side, how to protect ourselves is the key question, and that is through the indemnity insurance. What is indemnity insurance? It is compensation for damages or loss in the legal sense, and it may also refer to an exemption from liability of damages. The concept of indemnity is based on a contractual agreement made between two parties in which one party agrees to pay for the potential losses or damages caused by the other part. So, doctors are professionals who face the risk of a financial liability. In the course of practicing their profession, the amount they can be sued can be really exorbitant, as we see these days. The doctors therefore require a special insurance so that they can protect themselves financially and legally when they are sued for negligence. The hospital has a vicarious liability for the whole staff, nurses, doctors, anesthetists, and surgeons. It does not matter whether they are permanent, temporary, resident, or even visiting doctors, full-time or part-time. So if you are running a hospital, it is very important that you are required employ qualified doctors and nurses and get them covered. Their name should be included in the indemnity policy that you take for your hospital. But in solo practice, it is his or her responsibility, as he is the owner of the hospital, though it becomes less if a standby anesthetist is there. But in corporate trust and government hospitals, as I said, it is the hospital responsibility. It is a vicarious responsibility of the hospital, even for a surgeon visiting the hospital and operating in their setup. So even the name of the visiting consultant with the paramedical staff should be included in the indemnity policy that a hospital takes. So the range under professional indemnity policy provides for the extent of financial damage or loss caused to the victim against unintentional errors and omissions by the doctor. Also, insured qualified and non-qualified employees and staff, as the policy does not cover for criminal acts. Whatever policy you take, the policy doesn't cover for criminal act, and the cost of defending oneself in the court of law is covered, and the plan covers for 1 year. So the compensation from insurance policy, the policy will pay the sum assured that has been set as a limit. The expense over and above the sum assured has to be borne by the doctor. Here the sum insured is referred to as a limit of indemnity, and this limit is fixed per accident and per policy period. So there are various indemnity policies. What are the options before us? From where should you take your indemnity policy? So there are three basic options. One is you can take your indemnity insurance through medical legal consulting services organizations, or you can take from the professional protection scheme of the IMA, or you can take it individually from the professional indemnity policies provided by the national general insurance companies. The advantage or if you take an indemnity policy through a medical legal consulting services organizations is they give the support in consumer litigation. They give insurance like you take from a nationalized company like National Insurance Company, Oriental or United India Assurance Company. The guidance is given in maintaining the medical legal record. This is important, and advice, inspection of documents, preparation of documents, advisory support and advocate support will be given in stages of the consumer cases in all consumer courts and even in Supreme Court. Coming to the IMA policies, the aim is again the similar aim, and the eligibility is only for the life members of the IMA, and here the scheme is liable to pay the member maximum of rupees 5 lakhs. They have units of 3,000. A non-refundable membership fee of 3,000 rupees per annum needs to be paid for a cover of rupees 5 lakhs, and you can take additional number of units. If you take 9,000, you are covered for 15 lakhs, something like that. Subsequently, if there is a no claim, subsequently the membership fee reduces by 100 till you reach a stage of 2,500. And once a claim occurs, again you need to start back with 3,000 rupees per policy, per unit. And here the concerned member shall, the moment you get a notice, you need to inform the state representative of the scheme, and the concerned member will obey the instructions of the IMA management and should agree to their terms, and they will be giving you all the support, and you can fight out the case in the court of law. And should the IMA at a later stage advise you to file a counter claim for compensation from the patient in case of false claims by the patient proved in the court of law, in such cases the clause is that if you win a counter claim, 50% of it goes to the IMA. Now, coming to the third important part, if you want to take your own indemnity policies, what are the important things that you should know? That is, the insured policy includes the policy holding and his qualified assistants and employees. As I told you, you should include your assisting staff, and the policies are available for individuals, hospitals, as well as for diagnostic centers. The note and caution is short-term policies are not permitted. You have to take it on a continual basis. All claims have to be legally established. However, the company can offer an out-of-court settlement which should be accepted by the claimant. The jurisdiction is all Indian courts, and there is a group discount for over 200 members. And the calculation of premium depends on two factors. You should know this. One is AOA, any one accident, that is limit 23.5%, 33% or 50%. These are the things that you should read between the lines. If you take a policy, say for example 1 crore, and if the policy, if there is a claim for say 75 lakhs, but your policy states that it is 25%, that means per incident you are eligible only for 25 lakhs and not for the 75 lakhs claim that the case is sought for. So it is very important that you take your policy with 100%. Any one accident means 100%. That means whatever insurance claim the cover you take is valid for even one case. The premium for this is slightly high, but you need to take such a policy in order to, like why it happens is one insurance agent may come and say, I give you cover for 16,000 rupees for a crore cover. Another agent may come and say, I give you for 8,000. You will be tempted to take the claim from 8,000, but in between the lines, it will be written that AOA is 25% or AOA is 33%. That means for one particular case, you will be entitled to only for 25 lakhs or 33 lakhs as the case may be. So it is important that you take the policy cover for 100%, that is AOA should be 100%, so that whatever cover you take is applicable for any claim amount. The most important clause to be understood, the act has to be committed during the period of insurance commencing from the retroactive date and continued thereafter a break. So the take home message from this talk is, for professional indemnity, there is no grace period, and the policy should be mandatorily renewed before each date. Like in endowment policies, you have a grace period of 1 month. Even if you overshoot a policy date, you get a grace time of 1 month to pay up your policy and keep it updated. But for indemnity insurance, you have to pay before the due date. Otherwise, if you pay even 2 days after the due date, the retroactive date changes to the day you have taken the policy. Whereas legally, the patient can file a claim within 2 years of the date of incident. So since there is a break in the policy, you will not be entitled to compensation. This is the thing. So the two important thing is, always take your policy with a AOA any 1 year of 100%, and then also keep in mind that you need to renew your policy before the due date to keep your policy in continuation, maintaining the retroactive date, so that even if there is no break in the policy, only then you will be entitled for insurance claim. Otherwise, the insurance company will conveniently deny the compensation to you. So thank you very much for your patient hearing.
Thank you, Dr. Mathur, for giving a explanation about the insurance and how one can get rid of the